Web developers, are you worried about being sued over your inaccessible website? Tens of thousands of websites in the United States have already been sued. So in this video, we'll go over the law to keep you and your websites in the clear. My name is Dennis Walsh. I'm an intellectual property attorney and software developer, and in this video, we're going to deep dive the laws governing website accessibility. So I encourage you to watch the entire video because it's a fascinating look at how the law develops and adapts, and how judges can make completely contradictory rulings on the same facts and the same law. But I'm not going to make you wait until the end to get the answer. If you want to put your website in the best position to withstand legal scrutiny, comply with the Web Content Accessibility Guides from the World Wide Web Consortium, link in the description. But really, even that answer is not certain. I think as engineers, we want to know the why and the how behind the way that things work. So my goal in this video and this channel generally is to deep dive legal software topics to give you a full picture of the controversies and how the law actually works. By the end of this video, you will understand the really interesting issues, controversies, and unresolved questions behind website accessibility. So let's get into it. What backstops web accessibility is the Americans with Disabilities Act. Passed in 1990, Title III of the ADA imposes accessibility requirements on places of public accommodation. The Justice Department is tasked with drafting the regulations to implement the law, and in 1992, they crafted the Americans with Disabilities Act accessibility guidelines in the Code of Federal Regulations. This law and regulations changed public spaces for disabled Americans and businesses. For instance, businesses had to retrofit their existing structures to accommodate wheelchairs and similar aids. All swimming pools are now required to have accessible means of entrance, and many other physical structures and aids became required for spaces of public accommodation. But what about virtual spaces of public accommodation? The ADA is from 1990, so virtual spaces were obviously not contemplated. But there were technologies in the 1980s that created a legal foothold for websites, and that would be the telephone. Website accessibility requirements started from a TV game show, Who Wants to Be a Millionaire? In this really interesting lawsuit, a group of hearing and mobility impaired people wanted to be on the TV game show Who Wants to Be a Millionaire. The game show auditioned contestants solely through the telephone. The audition required listening to a question and then quickly responding on the phone's touchpad. Over 250,000 people called it daily. Before the smartphone, people really had nothing to do. Okay, so the plaintiffs argued that the lack of telecommunication devices for the deaf and the requirement to move fingers violated the ADA. The production company countered that the telephone was not a place of public accommodation. Now, there are two other defenses to the ADA that the defense could have argued. They could have argued that the modification would fundamentally alter the nature of the service, or the modification would create an undue burden. But the defendants simply said the phone isn't a public accommodation. So what do you think? Should the telephone screening be considered a place of public accommodation for the ADA? Let me know down in the comments and let's talk about it. So what did the court rule? The court found that the phone screening system is a place of public accommodation, and the rationale is kind of interesting. First, the court mentioned that the ADA covers both intangible and intangible barriers. Indeed, the ADA does mention intangible barriers like eligibility requirements and policies that restrict a person's ability to enjoy the goods, services, and privileges of places of public accommodation. But the second reason gets a little backbendy and, frankly, in my opinion, kind of odd. The court said the fact that the game show was in a studio, a physical place, that people with disabilities were effectively barred from that space because the only way to enter the physical space was through the telephone. There's a saying that bad facts make for bad law. Cases where the court reaches a just outcome, but where the facts and the law are contorted to reach that outcome, often leads to bad precedent. I think that happened here because with that rationale, we got a line of cases that try to relate a website back to a physical space. The fallout is that some courts require that the website relates to a physical space like a grocery store, while others do not. So let's quickly cover two cases to illustrate the tension. In Gill v. Winn-Dixie, a visually impaired plaintiff sued the Winn-Dixie grocery store chain because its website was incompatible with screen reading software. He argued that this made it impossible for him to access digital coupons, locate store items, and otherwise enjoy the full benefit of the company's offerings. The trial court and subsequently the 11th Circuit Court of Appeals focused heavily on whether the website was a place of public accommodation or simply facilitated access to such a place. The 11th Circuit's ruling was nuanced. It indicated that websites themselves are generally not considered places of public accommodation under the ADA because, like we covered before, the ADA lists physical locations as examples of public accommodation. However, the ruling also recognized that if the website acts as a portal or gateway to the store's goods and services, like how a telephone was a gateway to the game show's physical space, it may need to be accessible. The emphasis here was on the nexus between the website and the physical store. And because the website was limited in function, basically it just had digital coupons, prescription refills, and did not limit access to a physical space, it was not covered by the ADA. Several circuits follow this physical nexus test. For instance, in a case against Target's retail website, the district court in the Ninth Circuit held, quote, Target.com allows a customer to perform functions related to Target stores. For example, through Target.com, a customer can access information on store locations and hours, refill a prescription, or order photo prints for picking up at a store, and print coupons to redeem at a store. The court finds that to the extent that the plaintiffs allege that the inaccessibility of Target.com impedes the full and equal enjoyment of goods and services offered in Target stores, the plaintiffs state a claim and the motion to dismiss is denied. To the extent that Target.com offers information and services unconnected to Target stores, which do not affect the enjoyment of goods or services offered in Target stores, the plaintiff fails to state a claim under Title III of the ADA. So that physical nexus thinking is one line of cases, but as I mentioned before, the courts are split. In Andrews versus Blick Art, the plaintiff sued an art supply store for not working with a screen reader. But unlike in the Gill case, the plaintiff argued that being able to complete the purchase in the store was not good enough. Denying them on the website alone violated the ADA. The court held that the spirit of the ADA is to enable people to participate in their community and engage in commerce. To quote them, it would be a cruel irony to adopt the interpretation of the ADA espoused by Blick, which would render the legislation intended to emancipate the disabled from the bonds of isolation and segregation obsolete when its objective is increasingly within reach. If that doesn't sound like a legal argument to you, that's because it's not. This is judicial pragmatism. Essentially, a judge decides what's fair and then looks for any legal obstacles to block that decision. If they don't find one, that's the ruling. The court feels that it's good public policy extending the ADA to websites, and nothing blocks that ruling. I bring this case up, though, out of the thousands that I could have picked for the other side, because I think it does a nice job explaining the equal absurdity of the physical nexus test. This court specifically addresses the Target case by arguing, interpreting the statute in the Target way would require that only select aspects of Blick's website and online presence be accessible to the blind. For example, Blick would need to change its website to allow a blind person to find, successfully complete, and use the email list that provides for in-store coupons, but would not need to do so for the email list that only provides online discounts. Blick would have to make accessible information about products available for in-store pickup, but would not have to do so for items available only online, though presumably which item a category falls into could depend on the store selected for pickup and the inventory it had on hand. Putting aside whether such a design for a website is even feasible, the unworkability of it seems plain. And I agree with that. It is completely unworkable. And it can get even more nuanced. For instance, I've been in the automotive retail business. Does a car dealership's website need to work with screen readers? While it's obviously possible for a blind person to buy a car, in practice that never happens. They always show up in groups with other people that can help them make the buy. So with this circuit split, website accessibility could not be any more fractured. I've done a lot of legal research in my life, and this is one of the most convoluted areas I've ever come across. It's a complete mess. So please indulge me for one moment. I'm going to get on my soapbox and give you my take on the law as an attorney and a software developer. So I think the whole thing is ridiculous. The ADA did not contemplate websites, and because of that, I would rule that websites are not public places of accommodation. When the courts backbend, it lets Congress sit on their hands and not clean up their own mess. All Congress needs to do is show up one afternoon and pass a one-word amendment to the list of public accommodations that includes websites, or say that it doesn't include websites, and this entire disaster is solved. We have a mess because there's no clarity, and there's no clarity because Congress's stagnation and incompetence. I'm just tired of the courts needing to backbend and backstop society because we can't get lawmakers to follow up and clean up their own messes. Okay, rant. Okay, so in light of all that, let's re-answer the original question. Do you legally need to make your website accessible with some completely unsatisfying answers? First, you'll need to consider what your website is about and how it relates to physical spaces of public accommodation. Is it a Formula One racing blog, or is it Walmart? Then you'll need to consider where you live because of the circuit split and which courts may have jurisdiction over you and your site or business. Are you in the First Circuit, Third Circuit, Fifth, Seventh, Eighth? Take a look and find out if you have the physical nexus test. The Formula One blog may not need to be accessible at all, while Walmart, given that they're present in all districts, should make sure it meets all of the WGAC guidelines. Then the question becomes how to make the website accessible. I think one of the real frustrations for web developers is the difficulty and the nuance in figuring out that question. For instance, while researching for this video, I came across a lot of technical accessibility questions that I couldn't answer about my own sites. For instance, when my form is in an error state and I have an error toast, does a screen reader read that message? I have no idea. These questions are far more difficult than ones for the physical space. For instance, we all know what assistance in and out of a spa looks like, but do we have any clue what it looks like when a WebSocket connection drops? What should a screen reader do in that case? But I encourage everyone to not let perfection be the enemy of good. In reading these court cases, I didn't find any arguing about how effective the screen readers were. The defendants seemed to all thumb their noses and not even try. And practically, that makes sense. Imagine trying to fight a partial complaint website. The number of experts and cross opinions would be an absolute mess, and messes are not good for litigation or the plaintiffs. The Department of Justice endorsed the Web Accessibility Guidelines. Now, they don't guarantee you that it's enough, but in my opinion, practically speaking, after reading a lot of cases, I think it would be impossible for a court or a jury to award damages against a compliant website. Additionally, the U.S. Department of Justice posts a list of accessibility lawsuits it's settled, kind of a heads on pike style warning to others. But in reading those settlements, here's some of the language that should give us all a little bit of relief. So one of the settlement parts said, quote, a limited number of isolated instances of non-compliance with subparagraph A during the terms of the agreement shall not constitute a material breach of this agreement if those failures would not prevent a person with a disability from accessing the substantive information Rite Aid provides about COVID-19 vaccination, scheduling a vaccination appointment, or completing vaccination-related forms on the vaccination registration portal. So from reading all of these cases and researching for this video, here are my practical takeaways. The subset of the WCAG requirements that really matter are using semantic markup, ARIA roles where appropriate, use your dev tools to ensure contrast, give captions for videos, alt text on images, modals and errors that trigger screen readers, and good keyboard navigation. So there is your deep dive on federal accessibility law. California does have its own accessibility requirements. If you want me to make another video on that, let me know. And then let me know, what do you think? Tell me, are the courts right, wrong? Am I crazy? Probably. Let me know in the comments, and then like and subscribe so you don't miss out on the next two videos where I'm going to cover WordPress's criminal exposure and the PicRights web image shakedown.